Hello everyone, this is Tom Fox and I'd like to welcome you to episode 208 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions, your one-stop shop for all things FCPA compliance related. If you have not done so, I hope you will check out my blog, which I post daily. It's at the FCPA, it's called the FCPA Compliance and Ethics blog, and it's found at fcpacompliancereport.com. Today I take a look at an interesting set of facts which led me to conclude that compliance is at the tipping point in terms of the importance for an organization. I detail the 4 data points that I used to come up with this, talk about how they all interrelate together. The episode comes in at just over 21 minutes. I hope you enjoy it. Thank you very much. Hello everyone, this is Tom Fox and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. I am recording this podcast today at the offices of Workiva in Ames, Iowa, where they have a fabulous recording studio. So I'm getting to do my very first professional recorded podcast. So with that, I'm certainly going to celebrate that. And today I wanted to talk about why I think compliance is at the tipping point. I wrote some articles in September about the sea change in compliance. And then when talking to Roy Snell, who is the CEO of the SCCE at the 2015 Compliance and Ethics Institute, Roy put it in a way that I thought was much more powerful because he called it compliance at the tipping point. So I want to visit with you today about why I think compliance is at the tipping point. And there are 4 discrete points or data points and items that I think leads to this conclusion. They all were in September of 2015, and I think compliance is going to become even more important for corporations going forward. So data point number 1, the Yates Memo. Lots has been written about the Yates Memo. The Yates Memo was announced by Deputy Attorney General Sally Yates. It was entitled A New Policy on Individual Liability in Matters of Corporate Wrongdoing. And in this memo, the Department of Justice indicated a couple of things. First of all, that they would change their enforcement efforts to focus on individuals in white-collar cases. Obviously, the DOJ has prosecuted individuals in the past and will continue to do so in the future. So where this change really took effect, I think, is that the Department of Justice will now require corporations to investigate and turn over information on individuals involved in white-collar crime, including the FCPA, on a much more robust and quick basis. And indeed, the Yates Memo had the following statement: to be eligible for any, and any is bold, underscored, cooperation credit, corporations must provide to the department all relevant facts about individuals involved in corporate misconduct. Obviously, there was a lot of criticism of the department for lack of prosecutions of banks and other financial institutions after the financial crisis of 2007 and 2008. And whether or not you consider this response by the Department of Justice political in nature or not, it really doesn't matter, because what is the effect of that on corporations? Well, corporations now have to go after their own employees, and they have to go after senior executives who may have been involved in corporate misconduct. For the investigation, this obviously means you need to have very, very more than competent, very good investigators in place, because most prior investigations focused on the underlying facts. Because if you don't determine what the underlying facts are, you can't fix the problem. So most investigators tried to find facts and not assess blame. Well, that has now changed, and the Department of Justice wants corporations assessing blame on relevant individuals and presenting that information to them much more quickly going forward. So this has lots of implications for corporate not only investigations, but individuals, how much lawyering up they will do, how willing they will be to voluntarily participate in investigations, voluntarily participate in interviews, what types of corporate warnings must be given, how that information will be used, what is the privacy implications for any of this. All lots of questions, but I think this is sort of the first data point in this sea change of compliance at the tipping point. Immediately after, or almost immediately after the Yates Memo, we had the news broke about the Compliance Counsel from the Department of Justice. And this was something that had been known in the compliance community. But what happened was the name of the person the Department of Justice has identified and is vetting right now for this position. This is an outside consultant who will advise the Department of Justice on corporate compliance programs, best practices, and effective compliance programs. This is really going to ramp up the need for companies to have compliance programs going forward, and that's going to bring a lot more scrutiny to bear on compliance programs. I was really interested that Stephen Martin had some pretty powerful thoughts on this, and I'd just like to highlight a couple of those. First, he said that historically it's been difficult for compliance professionals to explain the return on investment in compliance programs to senior management and board of directors, and companies questioned whether the DOJ and SEC really credited pre-existing compliance programs or enhancements done during an investigation. The department obviously listened to these criticisms in the Morgan Stanley declination that has been extensively reported, but now the Department of Justice is furthering its focus on the importance of compliance by clearly signaling how intently they will investigate compliance programs going forward. But this is not simply in the investigation of the compliance programs, because the department will also use this compliance counsel to provide input into charging decisions, resolutions, and monitorships. By retaining a compliance consultant with both previous DOJ and in-house compliance experience, Stephen feels the Department of Justice is sending a strong message and signal to senior management and board of directors that it is now absolutely critical that companies have a robust and effective and sophisticated compliance program. This would really include moving beyond simply having a static program. It emphasizes to me the need to have ongoing monitoring of your compliance program, ongoing monitoring of best practices, and utilizing those to have your program continuously evolve. I often say that compliance is a business solution to the legal problem of the Foreign Corrupt Practices Act. Well, this is, I don't think any clearer or starker example could be set forth. Here we have the Department of Justice saying, we're going to evaluate your business solution to this legal problem, and we're going to hire a specific expert to advise us, the prosecutors and enforcers of this law, the effectiveness of your compliance program, and you will be assessed and really graded for a charging decision going forward. So I can't really underemphasize, or rather overemphasize, what I think this change is going to be. Mike Volkov has said that, also agreed that this is going to be a way for compliance counsel to perhaps even bridge the gap between antitrust and others in the criminal division to bring consistency around the issuing of credit that companies will receive for having an effective compliance program. So a different spin from Volkov, yet equally important that these could be incorporated into further revisions of the sentencing guidelines, updating and incorporating compliance developments into a more relevant set of standards which companies could have to utilize these. So if you couple these first two data points, the Yates Memo and the compliance consultant, I think we have the Department of Justice making two different yet interrelated statements to us. First of all, individuals are going to have to be called to the carpet and called to justice for their own violations of the FCPA. For corporations, having an effective compliance program is going to become even more important in a decision on charging going forward and what, if any, credit they will receive. And really, a third part that's not really focused on in either of those is one of the anomalies of the FCPA, which is that you can be convicted of FCPA violations through conscious avoidance. The Frederick Burke case is the poster child for this, where basically Burke put his head in the sand when red flags were presented around the transaction that his business group was involved in. He didn't even look into the background or character of the people he was doing business with. So we had clear conscious avoidance by Burke and actual criminal conviction and jail time. This was upheld by the Second Circuit Court of Appeals, so the legal theory the Department of Justice utilized was validated going forward. So if you couple conscious avoidance and the Yates Memo and the Compliance Counsel, I think it's at least clear to me that senior management is going to have to take a more active role, be more involved in having a truly effective compliance program in place. I think this could extend up to the board of directors and specifically the audit committee. The audit committee is obviously tasked with oversight, and an audit committee may have to now be more aggressive and more forthcoming and more straightforward in asking some basic questions and then moving to ask to more difficult questions. So the conscious avoidance prong of the FCPA could really lead to some very, very difficult situations for senior executives and boards of directors who do not follow the prescriptions of having a best practices compliance program in place. Now we've got a compliance consultant with the Department of Justice who can tell us, or at least tell the department, advise the department on what may be a best practices compliance program for credit and charging decisions. And these changes make it very, very important that compliance have greater visibility at all levels of the company, from the lowest shoproom floor all the way up to the boardroom. The next data point is outside the FCPA realm and the FCPA space, but I think it's going to be one of the largest corporate scandals of all time, and that's the VW emissions testing scandal. This is not an FCPA case. This is an environmental scandal. This is not the failure of a compliance program. This is a complete, total, and utter intentional decision and action by Volkswagen to violate the emissions testing the emissions testing standards of the United States, of countries in Europe, and indeed countries across the globe. They have 500,000 cars in the United States, which had installed in them defeat devices, which were software to defeat emissions testing protocols. But that was just really not a drop in the bucket, but 500,000 out of 12 million total cars. So a huge scandal. The cost to VW already has been astronomical. They've lost 40% market cap. They have reserved $7 billion to pay for fines and penalties. Yet, in the United States alone, they could have costs running up to $18 billion. That's just on the fines and penalties side. That does not count the cost of car buybacks. That does not count the cost of shareholder litigation. That does not count the cost of distributors of VW products in the United States who were also defrauded by the company in Germany. So that's the cost. But what makes the VW scandal even takes it into a level, a stratospheric level that we've not seen before, is the damage to the German national brand. Americans think of a German product generally in two ways. One, they think of quality, and two, they think of honesty. Now we have a scandal so bad, so all-encompassing, that it has damaged the national German brand. If that theory holds true, and if it continues to hold true, and it turns out that up and down the chain at VW, there were people involved in this, then I think the German government will take a very aggressive response, both in terms of prosecuting Volkswagen individuals, senior executives who were involved, perhaps engineers, and having a legislative response in tougher laws and penalties. But the scandal was so bad that it damaged the brand of other German car manufacturers. So Mercedes-Benz or Mercedes, BMW, their emissions testing has now been called into question. And this is the first example I can think of where a scandal was so bad, it was so encompassing, it was so all-encompassing that it damaged competitors. And if you are going to be put in a situation where a competitor's action can damage your brand, I think the only response, the only way to save your reputation in the hyper-transparent, reputational damaging world we live in today is to have an effective compliance program. Mercedes and BMW have to be able to immediately show regulators, here's the testing protocol we have, here's what we've used, here's how it tested out in the lab test, here's how it tested out in the road test. They are relatively consistent. They're consistent that the documentation is there, and they can stop the damage to their brands because of the actions of Volkswagen. So we have a really, I think, a first where a competitor has damaged the brands of the people or the companies that are in its space. So we have something that is so bad and so all-encompassing that it's damaged not only competitors but the national brand of Germany. And this is the first time we've seen that. We've not seen that in the FCPA space. And the only answer is an effective compliance program. And then the final data point that I would like you to consider is what happened in the European Court of Justice decision in the Schrems case. This actually came out in early October, so I can't say it was all in September, but the Schrems decision invalidated the safe harbor provision of data transfer from Europe to the United States. There are a variety of legal reasons for this that I won't go into, but it's going to have a hugely practical impact on compliance practitioners, chief compliance officers, and compliance programs going forward. Now you cannot take evidence or information, or you may not be able to take it from your own company in Europe to the United States. This information could be about your hotline, anonymous reporting, and it could also impact your investigations. Now think back to the Yates Memo. What does the Yates Memo say? Mr. Corporation, you must absolutely positively investigate your senior executives and individuals immediately and turn that information over to the Department of Justice. Yet, after the Schrems decision, you may not be able to take that information outside of Europe. And indeed, you may not even be able to do the investigation because to obtain that sort of private information, and remember in Europe, emails are private, unlike in the United States where they typically belong to the corporation, you may not be able to get access to emails. You may not be able to interview. You may not be able to take a statement from an individual without that individual's consent. And to get consent, you have to explain to them that you are going to investigate them. This may be information that's turned over to the Department of Justice, and they may be prosecuted individually, indicted, and extradited to the United States for prison term. What do you think the response is going to be when you tell anyone, no, that's the consent, that's the effect of the consent we would like you to give us? The answer is going to be, I'm not going to give you that consent. So we have, in the face of the Yates Memo and Compliance Council, where investigations focused on individuals have become heightened from the Department of Justice's perspective, to the Schrems decision that companies may not be able to take that information to the United States. And indeed, you may not even be able to ask those questions or obtain private information without informed consent now. And if you don't get that informed consent, the lawyers who engage in that activity may be criminally liable in Europe. So the anomalies here are just abounding, And I don't pretend to know what the answer is. I do know that the answer is going to be much more difficult for you going forward. So the answer and the response to all of these, I think, is compliance. Compliance, an effective compliance program, a best practices compliance program, having robust internal controls, compliance internal controls where you've mapped your internal controls from the 10 hallmarks of an effective compliance program or other compliance regime to the COSO framework, whether that be the 5 objectives, the 17 principles, or the 84 points of focus, and you have that information available to you as a detection mode, but also in prevention. The pressure that's going to be put on prevention and detection is going to be much greater now with the advent or these other actions. With Volkswagen, though, because this scandal was so encompassing and so large and so damaging to such a broad number of industries, competitors, and indeed the German national brand, the answer to that is compliance. It's compliance with the laws. It starts with the board of directors, who apparently weren't doing their job. Senior management was either in on it or asleep at the switch, and then all the way down the chain. The CEO now better be calling his chief compliance officer and bringing that person in and saying, look, you need to get a handle on this. You need to put a technological solution in place which allows you to have line of sight visibility on a wide variety of topics. That's going to be the only way a corporation can protect itself from the government when the government comes calling in an FCPA investigation. And in the worst case scenario, along the lines of the Volkswagen scandal, in the hyper-transparent world of reputational risk, how are you going to protect yourself unless you have a robust compliance program in place? So I think compliance is at the tipping point. I think these 4 data points have going to lead us to past the structural changes, which led to CCO or Compliance 2.0, past or including Compliance 3.0, which is the data sources available in social media that compliance can use, to a more robust technological solution moving forward. Compliance will be elevated and compliance will become much more important. And if the CCO is not in the C-suite, this will move towards all of this. So that's my thoughts on why compliance is at the tipping point. If you have any, I hope that you would share those with me. You can email me at tfox@tfoxlaw.com. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance and Ethics Report. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I have two calls to action for you. The first is, please go to iTunes and rate this podcast. I would greatly appreciate it. The second thing is, I am developing a list of questions for my next mailbag episode. So if you have any questions you'd like explored, please email me at tfox@tfoxlaw.com. This is Tom Fox, and thank you very much for listening.